right here at the station for the man and the woman who matters. David Tulis, we are arguing for defense of your rights, and we are looking for answers, and we have on the phone Dave Myrland. Dave Myrland is a legal expert. He is a jurist, which means that he knows a lot about law, and he is wanting people to understand their rights in a way that they can use the law for their own protection and defense. He is in Seattle. He's 60 years old. He's a jogger. His nickname is Dave Data Myrland. And he has been involved in many fights with courts, with top tax attorneys such as Mr. I think Zuckerberg, in overseeing the tax division in the Justice Department, swapping briefs with him. Again, trying to defend the rights of the individual American. We are here all about Americans and making Americans a freer and better people. Dave, I have before several jurisdictions in the Chattanooga area what's called transportation administrative notice, and you are among of your areas of study is the doctrine of notice. And I'm arguing that there is a gap, a fissure between practice, law enforcement practice, and the statute, and many court cases from the beginning, 1917 Shannon's Code, and the earliest provisions of Tennessee law. A distinction between travel and transportation. The state regulates transportation. Travel is left to the individual. Even the appearance, I argue, of the Driver's License Act in 1938 and 39 did not damage or destroy any constitutional right, and that it is possible still for listeners, though we have a driver's license regime, to travel by car. Though enforcement policies in every jurisdiction, 100% of jurisdictions in Tennessee, say that you can't do that. It is illegal. It is a crime to travel privately. What are the prospects, would you say, of this notice project as far as you can understand it? Dave Myrland of wevgov.com.
You went from one enormous topic in your introduction into another enormous topic and then asked a question.
Sorry.
You really have to stay with the notice part first. And I don't argue that I have a right to travel. I always argue they have a statutory limitation on their authority. It's a totally different argument. I'm not asking for an interpretation of my rights under the Constitution because it's an American judge. And judges are every one of them. Every one of them is as corrupt as the day is long. Corrupt means criminality. Criminality can be very simple. Like 18 U.S.C. 241, a felony, conspiracy against rights. If two or more people, like the prosecutor and the judge, conspire to threaten, injure, oppress, or intimidate somebody in the enjoyment of a right or privilege secured under the Constitution and laws of the U.S., 10 years in prison. So if they're trying to get my money in traffic court and they violate a court rule and they've used the mail, it's all federal. I can arrest them if they violate a court rule in traffic court. Can you hear how powerful the law is? Now, for your audience, online, on that page I gave you, wevgov.com/ O, RTH, Orth, that's his last name. wevgov.com / Orth with a capital O. On that page is a criminal complaint to the FBI that man filed because of the way the court treated him on the Seventh Circuit against Diane P. Wood, the chief judge of the Seventh Circuit, and two circuit judges. They, in the opinion, they work together on this. It's a conspiracy if it's a violation of rights. Right there is a criminal complaint of the kind the panel, the Citizens Review panel, would issue. It's just an affidavit. But if a panel of several people, maybe even a professional on the panel, sign off on that instead of just this man, 7 people think everybody in the world can come here and arrest these 3 Seventh Circuit judges. How is what they did to him not mail fraud? So that's all you're saying. But now look at the political component. Every public servant has to keep intact to keep their pay. That's what you're after, is to make it unpopular to employ them by identifying their misdeeds. It can be very simple. It might even be grandiose, like a false prosecution when they know the guy is innocent. How is that not a kidnapping and a conspiracy against rights? That carries the death penalty under 18 U.S.C. 241. If you conspire against rights and it includes an attempted or actual kidnapping, you could get the death penalty. Here, listen to how easy it is to fall into federal criminal jurisprudence. Don't do it. When you know this much about the criminal code, wevgov.com, get into the website. On top of the menu column on the left, there's a YouTube 1 and a YouTube 2. YouTube 2 takes you to my YouTube channel called Take from Caesar, with a bunch of law tutorials. YouTube 1 will take you to a page that has a video about Citizens Oversight Commission. In my book, No Confidence, Civil Liberties versus Homeland Security, which is available through wevgov.com, I have a statute that provides for a citizens review panel that gives the panel authority. If that's what you want, if you want authority, saying the panel's decided this officer has to go. This is the statute I wrote providing for it. I wrote it in 2003. This is all very old stuff. And I'm surprised Dave contacted me about it, not knowing that I've done this work. And I've already pinned the tail on that donkey. And so, No Confidence, Civil Liberties versus Homeland Security. This statute or municipal ordinance, depending on where the citizens choose to aim it, can give a citizens review panel the authority to determine not whether or not somebody should be criminally charged, but be able to determine, because they should be, in the eyes of the panel, criminally charged, we feel they're unfit for employment, they're out of here.
All right, let's back up, Dave. Dave, let's back up.
Go to ballot.org, and you'll find great work on what different states can do regarding citizens referendum and initiative. Go ahead, Dave.
Well, I wanted to get back to the question about administrative notice, and you said there's a distinction between notice and one other thing, two big topics. Let's do the first one first. The idea of notifying officials about about the limited scope of the statute. And the reason I've done that, as I was telling a police officer who was protecting the city council meeting Tuesday night, was to create a cause of action that is already there, a cause of action against the individual officer in civil court, a tort claim. If he's been notified of the limits of the transportation statute in Tennessee, he can't possibly arrest somebody or charge somebody under that statute. If that person insists that he's not involved in that title and not involved in transportation, and in fact he's a private user, state your authority, sir. He doesn't have authority. If he goes ahead and arrests that person for not having a license or showing a license or anything else, that is a tort. And so what I've done is try to create a cause of action individually against the officer. And it has to be, the plan has to aim at the officer, Dave Myrland, because state policy and judicial, you might say judicial activism, prevent there from being appeals, making the distinction clear by opinion, new opinion, that transportation and travel are distinct, and that transportation is a category of travel. Travel is free, transportation is commercial and for profit, extraordinary. So what do you make of the prospect of my notice project, and how do you evaluate that?
Of all people that interview me, you're my favorite. Listen to that question that you just asked me. Okay, we're going to compartmentalize. You're great. Now, first things first, what do they have to consider before they arrest somebody? There has to be probable cause. People can listen back to this show. Okay, I'm going to speak freely here. Matthew St.
I'm not giving legal advice.
Versus City of Alamogordo, New Mexico Police Department, where the guy's lawsuit for unreasonable seizure was dismissed by federal district court, and appeals reversed it, saying, oh no, he has a claim the officer had no reasonable suspicion that a crime had been committed, was being committed, or was about to be committed, and therefore, when they dragged him by the arm, escorted him out of the theater because he was wearing a gun on his hip, it was an unreasonable seizure. But the request for his license and taking of his gun while they called him in to see if there were warrants was a reasonable search. Okay, so there's a great discussion in that case, Matthew St. John versus City of Alamogordo Police Department, on probable cause. Before they suspect a crime has been, is being, or will be committed, their authority has to stay where it's at and not show itself. Okay? That's the standard you have to take to every government action. Secondly, they have to have reasonable suspicion of guilt pursuant to each element of the offense. If the element says, whoever knowingly, will stop right there. Where's your probable cause to believe they knew they were breaking the law? When I just heard this story, a lady on the beach, I don't know, South Carolina or something, Florida, collecting conch shells, the big snail shells. But there's a law that makes it a crime if you pick one up and take it that has a creature inside of it. And so they criminally charged her, and she's on probation and has to pay a fine. How would she know? Okay, and this is a 2015 case that refreshed everybody's memory about criminal intent, Alonis versus United States, ELONIS. And they said, we told you this in 1952 in the Morissette case, you have to have criminal intent with every crime.
That's right.
They forgot that element, and they don't even include it. And so innocent people go to prison all the time. So you want to make sure you notify them of the law and notify them also, which you do not do in your notice, of the Supreme Court decisions on criminal intent being required. Look up some on your circuit. They're going to be there. That mens rea, criminal intent, is a requisite element of every offense. I found it in Kentucky law a week ago. It's actually in statute that you have to have criminal intent.
In Tennessee, it's in the statute too, Dave. In Tennessee, in Tennessee, it's in the statute.
And so, if just ask me for my briefing of criminal intent, okay, I just did it for the Ninth Circuit. It's deluxe, Supreme Court and Ninth Circuit. So anyway, I need to pave the road for them to say, don't mess with a guy. That's number one. You need to keep them at a distance. I urge you to study proper legal citation and punctuation. Look at the briefs that I've got online.
Dave, move along here. Dave,
tax attorney.
Move on to the question about this notice. We're having a traffic stop. Notice is in view. Private user, maybe an immigrant here in East Ridge, Tennessee, without a license. What's going to happen here? How do we make this notice system work?
Right, and I suggest you not leave it to a traffic stop. You got to sandbag the municipality through the mail, regardless of whether you drive. It can't be done at a traffic stop because the police officer has a job. They got a quota. They'll never admit it, but we know it. And so my urging, what I teach, what I urge everybody to do, and this is just me, I tell them, you make the traffic stop as short and as sweet as possible and get out of the proximity of the policeman.
Well, how do you do that?
The rule.
How do you do that and maintain your rights?
Take it up with court.
How do you do that and assert your rights and not yield any rights at the stop? Because everything you yield, if you have a license, all that information is yielding. It's all making admission of being involved in commercial activity. Dave Myrland.
Yeah, and there's the instance here in Washington. I handled the case. The motorist says, well, I see your gun, your lights, your badge and everything. Can I see your evidence of authorization, please? That's the photo ID the department issues to every policeman here in Washington State. They have to prove at a traffic stop they're a bona fide policeman. And if they don't produce it, it's a misdemeanor. And what does this cop do? King County Sheriff. He leans into his lapel mic and says, give me backup. I've got a constitutionalist. And the guy was charged with resisting arrest, failure to obey a police officer, facing a 1.5 years in jail when I met him at one of my seminars. Why would you stay in the presence of a policeman? John T. Williams. Search wikipedia.com. The shooting of John T. Williams, Native American sitting on the curb in downtown Seattle in August of 2010, and whittling with a 3-inch blade on a piece of wood. He's part of it. He's in a club, and police officer, drop it, pulls his gun out. And he wouldn't. He stands up and he goes, "What's your problem?" And the cop shot him 4 times and wasn't even charged with anything. They found the shooting unjustified and let the guy quit and move away.
All right. Well, the question though is, how do you make a traffic stop short, getting yourself out of the presence of the officer, but not yielding any rights?
Yes, sir. No, sir. I'll take it up with the court. Thank you very much.
Just agree to a citation?
Oh yeah.
Well, he's going to want to see your driver's license and so on. What if you don't have one?
And
what if you're an immigrant?
And I would produce it. You got to take this up in advance and tell them, I'm going to be out on the road. The panel's already decided your enforcement is a felony.
Okay. Well, you're assuming, all right, your analysis there, Dave, assumes that this review panel exists already, but it doesn't exist here. It does not. And so how is someone using an actual legal claim made upon these local jurisdictions, which is my notice, how can they take advantage of the notice? What is the effect of notice about the limits of enforcement authority? Is there any value in this project at all, Dave? That's what I'm asking you.
Okay. On my YouTube channel, which is called Take from Caesar, I've gone to wevgov.com, get into the website, left-hand menu column at the top, click on YouTube 2, seek out the public vehicular travel video, and I describe the travel argument. You have to go to Tennessee law and brief it as best you can with everything you've got. And this is, I would add this to your notice. It's on my public vehicle or my motor vehicle code page, Dave. Buck versus Kuykendall, 1925. The Supreme Court says the citizen may have a right to transport his property on the highway, but it's altogether a privilege to use the highways as a place of business. The Supreme Court is not allowed to do that. They were pointing out, excuse me, everybody, there might be a right involved here, but it wasn't part of the case, so they couldn't expound upon it. But anyway, I would include Buck versus Kuykendall. It's like, please tell me how the Supreme Court was mistaken here. They said I might have a right. Tell me how I might not, servant. So anyway, if you preempt this saying, I know your enforcement to be felonious, I've got Tennessee law right here, and I've got a course that comes on flash drive. I've also got a publication called Public Vehicular Travel, America's Forgotten Right, and it's a criminal complaint to the Department of Justice that Kurt Riggin and I filed March 9th of 2006 with the Department of Justice and with Congress, calling it racketeering here in Washington State. You do research in kind in Tennessee to show the original scope was that the Motor Vehicle Code shall apply to people using the streets as a place of business. It's never been broadened by the legislature. That's another argument that's not in your notice. It's a separate and valid argument. The legislature has never expressed an intent to apply the Motor Vehicle Code to people who do not use the roads as place of business. There. And you use the original definitions from your first motor vehicle code, as I've done in Washington State. And then you allege racketeering. The legislature's never authorized this, and you're taking my money for motor vehicle fuel excise tax, motor vehicle tire excise tax, license fees, tabs annually, title transfer, all of it's motor vehicle, emissions tests. In Washington State, as you'll see on my website, on the Motor Vehicle Code page, in 2003, they amended the second-degree car theft statute here in Washington State. That recently, it says in 3 places, automobile or motor vehicle. They're 2 different things. Every motor vehicle is an automobile, but not every automobile is a motor vehicle. That's a class of conduct, using the highways as a place of business.
Right. The use of the car, the use of an automobile.
And then issue the criminal complaint with the signature of everybody on the panel and say, we know it's racketeering, and anybody with this window sticker says they're part of the panel or part of this effort, don't pull them over, or we're going to charge you, we're going to arrest somebody.
Well,
get arrested.
We're talking with Dave Myrland of WeVGov.com in Seattle. That's WeVGov.com, and he's pointing out some gaps in administrative notice. So it sounds like I might be on the right track, Dave. You think I'm close?
Yeah, you're starting.
Okay. Well, listen, Dave, thank you so much for joining us on the David Tulis Show here at Nougat Radio. Thank you very much, Dave.
You call me anytime.
Yes, sir. Thank you. We're talking with Dave Myrland at WeVGov.com, and he says there's hope for success in my administrative notice filed in Chattanooga and several other jurisdictions. Aid for the poor, the African American, the immigrant, and everybody else. Let's start with the people most abused and help them first.
3, 2, 1.
Chattanooga Radio. Digital FM 95.3 HD4. 92.7 FM's news now.
No charges were pressed against a former Hamilton County Sheriff's deputy who allegedly met with who he thought was an underage girl. Ryan Parker was caught by members of a Facebook group called Parents Against Predators Nationwide.